1789 today, and this bill is basically the Second Amendment of the Constitution of the United States and Article 1, Section 13 of the Constitution of Virginia. It basically gives a description of things that are protected under these two constitutional clauses. The bill also goes on to talk about how that the rights of the citizens can't be infringed upon. But the final part of the bill, that any person who knowingly deprives or attempts to deprive a person of their constitutional rights can be held civilly. I feel that this bill would do a lot to make the Second Amendment people satisfied.
Thank you, Delegate Campbell. Is there any questions from the committee at this point? Delegate Davis.
Mr. Chairman, Delegate, I can appreciate the bill you've got here, and I definitely want to make sure we recognize the Second Amendment rights for our citizens in the Commonwealth. Just for clarification, and I understand why, but under Section E, if I'm reading this properly, if a law enforcement officer is given a court order to execute on behalf of another person that would remove their firearms in a manner that one deems may be infringing on their Second Amendment rights, they can be held liable under this piece of legislation, correct?
Yes, sir.
Okay, thank you.
Delegate Elmer.
Mr. Chair, I'd ask Delegate, what forms of gun control do you view would be constitutional and therefore appropriate and not covered by the statute?
Criminal. Yeah, criminal history.
I'm sorry, I didn't understand. Said if you have a criminal history.
Any other questions or comments from the committee at this time? Is there anyone here speak in favor of the bill? Anyone else to speak in favor? Anyone to speak in opposition to the bill?
So in section, this is Josh Horowitz, Educational Defense Subcommonwealth, thank you for this opportunity. Section D, it says no person shall enforce any law, executive order, blah, 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 or court order that unlawfully infringes on a person's right to lawfully keep their arms. So in 1787, founders of this country came back to Philadelphia because the Articles of Incorporation, which gave legislative supremacy, didn't work. We had anarchy, fighting in the streets, and major disorder. And George Washington and other founders came back to Philadelphia because they needed a different system. That system included, of course, our three branches of government. That included our legislature and our courts, and none of those is supreme. This would give legislative supremacy to void court orders. That is one of the most anti-democratic and anti-constitutional things that I've seen this year in the legislature, and I urge you to defeat this bill.
Mr. Chairman, Andrew Clark, News Centre for Public Safety. This seems to be based on the assumption that a legislator can choose what definition of the Second Amendment he chooses. Actually, the Second Amendment has been very well defined in Heller versus District of Columbia and in McDonald versus City of Chicago. So we already know what the Second Amendment covers, and if it's unconstitutional due to what Justice Scalia said, then it wouldn't be enforced anyway.
Good morning, my name is Lori Hosley with the Coalition to Stop Gun Violence for the reasons stated, and just to note that we regulate the right to assemble, have to get a permit, we regulate speech, we regulate all our rights for public safety and for a myriad of reasons. We strongly oppose the bill. Thank you.
Bring it back to the committee for discussion. Delegate Davis.
Mr. Chairman, I can appreciate the delegates' intent with the bill and the desire to protect the Second Amendment rights that I think everyone in the Commonwealth has been reading about, and obviously we've seen a lot of bills that I think a lot of us believe already infringe upon that coming through this year. However, I hesitate with this bill because in Section E, I hate to put a deputy between executing a court order that he lawfully, per his oath, may have to execute, and then potentially making him liable for damages in doing so per this piece of legislation. So with that, Mr. Chairman, I would move that we lay this bill on the table.
Second. It's been moved and properly seconded to table House Bill 1689. All members ready to vote? Clerk will open the roll. Members will cast their roll election. Vote on the board.
This bill, this addresses sanctuary, Second Amendment sanctuary localities, and it just says that, a Second Amendment sanctuary status of any particular locality cannot be used, in budgeting decisions. Over the last couple of months, well over 100, communities have, declared themselves Second Amendment sanctuary status, and there's a concern that that could be used against them in allocation of funds.
Any questions from the committee members? Delegate Helmer.
Mr. Chair, I'd ask the delegate, so if, in the governor's budget, there is funds allocated for gun violence prevention measures or support, towards which a county has indicated it will not use that funds in those ways, would this bill then make it inappropriate to not allocate that money towards that county?
Well, I would say to the delegate, Mr. Chairman, that if the county said they wouldn't spend the money, I would think that the governor would, that they would not accept the funds. This is saying they can't use it in, budgetary decisions.
Delegate Helmer. Anyone else at this time?
Mr. Chairman, if I may.
Delegate Davis.
So, Delegate, so all this does is just make sure that when it comes to the budgetary decisions, that we don't discriminate against localities because of their belief in Second Amendment rights. Would that be accurate?
That's correct.
Okay, we'll take some public testimony. Is there anyone here to speak in favor of the bill?
Okay, please, BCDL, strongly support the bill.
Tricia Webb, Hanover County, NBCDL. It is the job of government to uphold the constitutional rights of the people, so when these localities have passed resolutions to do just that, they should not be penalized, so we support the bill.
Mariah Rowland, Louisa County, support this bill.
Anyone else in opposition, support of the bill? Anyone here speak in opposition to the bill?
Josh Horowitz, Educational Fund, Stop Gun Violence, thank you for this opportunity. Because of these resolutions and because of some of the issues that might rise from it, for instance, failure to prosecute crimes, there could be wildly different budget needs according to this. So I think if you're gonna pass this Second Amendment sanctuary and you are actually not gonna prosecute crimes, that may actually reduce your felony total with your Commonwealth attorney, may reduce at a very, not in a non-discriminatory way, but just based on need, may very well reduce the needs of the Commonwealth Attorney's Office in those areas. So I think saying you can't base budget decisions on this is very short-sighted.
And oppose the bill.
Mr. Chairman, after going over Virginia Center for Public Safety, this presumes that the Second Amendment sanctuary is a legal thing, and I don't think that's been decided yet in the court.
Good morning, Lori Haas with the Coalition to Stop Gun Violence. We oppose the bill.
Anyone else here to speak in opposition to the bill? Back to the committee for discussion.
Mr.
Delegate
Chair.
Davis. Delegate Bennett.
I was gonna say, so I see the language in here about Second Amendment sanctuary status, and I know a lot of localities, mine, in my district included, did not refer themselves as such, they called themselves constitutional counties. How would this be specific to people who passed a resolution that said that they were a Second Amendment sanctuary, or would this cover all those other kind of mixed bags of terms that are out there? Should it be amended to specify that?
I mean, that'd be up to the subcommittee. I would, intention to cover all of it.
Mr. Chairman?
Delegate Davis.
Thank you. I mean, so per the last person's comments, I mean, I understand that the legality of a Second Amendment sanctuary city and its, I guess, authority may be in question from a legal standpoint. But what I like about this bill is it says that the executive branch shall not consider the Second Amendment sanctuary status of any locality. So whether it's perception, whether it's the locality considers themselves one, even if it's deemed that it's got no legal authority with respects to overriding state control, which very well may be the case, this just says that if we decide that we want to uphold the Second Amendment in our Constitution, that the executive branch cannot discriminate when it comes to funding. And I think that's simple. I think we probably all agree with it, and for that reason, I would move the report.
Let's see if there's any more discussion. Delegate Helmer.
I was gonna move a substitute motion.
All right, let me make sure there's no other discussion, no other comments. Delegate Plum.
The state aid to localities goes up and down over the years for a variety of reasons. I can foresee a situation now where your school enrollment goes down, your basic aid goes down, your Second Amendment, and you end up in a legal battle about whether that was because of your Second Amendment sanctuary, which had nothing to do with it. So it creates an unknown, that makes us see how we maneuver ourselves through.
Any other comments, questions from the committee? Seeing none, I'd entertain a motion.
Mr. Chair, I move to lay this bill on table.
It's been moved and properly seconded to table House Bill 1409. All members ready to vote, clerk will open the roll and we will vote electronically on the board. Close the roll. House Bill 1409 is laid on the table by a vote of 5 to 3. Thank you, Delegate Rush. Delegate Freitas.
Thank you, Mr. Chairman.
Mr. Chairman, members of the committee, House Bill 224 is essentially commonly referred to as constitutional carry. The thing that's a little bit different about this one is we don't actually get rid of the concealed carry permit. We just simply say that if you are legally allowed to open carry in a particular area, then you should have the option of being able to conceal carry without having to have a permit to do so. Again, we leave the permit in place for reciprocity reasons and everything else, but again, I think it comes down to an issue. If I can open carry, then I so choose, then I prefer to carry discreetly, then I should be able to do that without having to go through an additional process. With that, I'll be happy to take questions.
Any additional questions from the committee? Delegate Davis.
Thank you. Delegate, so, if you can help understand just for the committee when it comes to concealed carry, am I correct that if I am open carrying and then put a jacket on, and that jacket happens to cover my weapon, would that be then considered a concealed carry? And if so, in your opinion, does that present any other challenges or difficulties that the person may have that they should have additional training on before they put a jacket over their firearm?
So, yes, could be considered concealed at that point. And no, I think having a jacket on does require a great deal of additional training or expertise or legal review in order to be able to do that. In fact, I would say in most cases, people would probably prefer to carry concealed. So if you imagine a situation where, somebody felt the need to own a firearm, knew how to use it correctly, but hadn't gone through the process to get the concealed carry yet, they could walk into a store or whatnot, or walk down the street with it open, but, again, just for the purpose of being more discreet, they might want to put on a jacket. Why wouldn't they go through an additional process for that?
Thank you.
Delegate Humble.
Mr. Chair, delegate referred to somebody who knows how to use a weapon and wants to carry it safely, and I just wondered if there's any provision in here to ensure that the person actually does know how to use the weapon and prove their competency on it before we allow them to conceal carry in public.
No, we're not gonna, well, again, we don't have any requirement for them to, we don't put the government in the position of determining that you have to meet this particular criteria before you can own a firearm and carry it openly, so the question is why wouldn't we allow them to carry it concealed? Especially when, I would say that in many cases, that might make people around them more comfortable if it was concealed as opposed to open.
Delegate Humble.
Mr. Chair, one quick follow-up for the delegate, since delegate acknowledges that we don't necessarily require that training for open carry, wouldn't that therefore carry over concealed carry, would the delegate entertain an amendment to this that required training for the open carry of weapons to make sure that we were level-setting them both the same way?
I would not consider that a friendly amendment.
Thank you. Seeing no other hands raised.
Smart.
Is there anyone in the audience who would wish to speak in favor of the bill?
Philip Van Cleve, ECDL. There are 16 states that have implemented constitutional carry. It's been a perfect success in all of them. In fact, the one with the lowest crime rate in the country, violent crime, is Maine, which has constitutional carry. So it's not an issue, again, as the delegate said, putting on your coat doesn't suddenly change anything other than the gun is now is simply not visible. So this works where it's tried, and we're not having a problem with open carry. We haven't had issues where people, lack of training or anything has been a problem. So we strongly support this bill.
Tricia Webb, Hanover County, BCDL. For all the reasons that Philip said, I will remind the subcommittee also that when we went to shall issue on the concealed carry permits, there were fears of rivers of blood running down the streets. That hasn't happened. In the 16 states where constitutional carry is permitted, there were also fears of increase in crime. It hasn't happened. It's actually decreased crime. So we strongly support this bill.
Mariah Rowland, Louisa County. As I've told this committee before, you're absolutely right. Putting a coat on does make you a criminal if you do not have your concealed carry permit. The other issue that none of us have discussed at this point is when you realize that your coat or your sweatshirt has covered your weapon and you go to uncover your weapon to make sure you are in compliance with the law, somebody sees you do that, they could be nervous, uncomfortable, and then declare you brandished your weapon. So it becomes a catch-22 for you. Allowing this to go through puts us all in a better place. We can choose to conceal carry, we can not worry about if your code covers it, and it gives you that ability. I urge you to support this bill.
Anyone else here to speak in favor of the bill? Anyone here to speak in opposition to the bill?
Josh Horowitz with the Educational Fund, thanks for this opportunity. As far as the Rivers of Blood comment, I think it's important to understand that, it depends how you define this, but the amount of research is piling up that concealed carry increases year-over-year crime rates in states that have it by 2 to 3%. So I don't want to say there's a river of blood, I just want to say statistically there's more criminal activity in states with concealed carry, and the evidence is mounting on that every single day. And so expanding these types of laws is a bad idea. I believe we should go in the reverse, making it harder to get a concealed carry license, make sure that we do not increase criminal activity in the state. So we oppose this bill. Thank you.
Mr. Chairman, Andrew Garr, Virginia Center for Public Safety. First of all, the term constitutional carry implies that the Constitution says something about you being able to carry a concealed weapon. Carrying a concealed weapon is illegal. You only get an exemption for it if you have a permit. I can say that I'm wearing constitutional shoes, but it doesn't make them part of the Constitution. So that's one point. The second point, how do you prove to a police officer that you are otherwise able to pass the test for getting a concealed carry permit? And finally, getting a concealed carry permit is ludicrously easy currently. I got one and I've never had my hand on a handgun. So it's not a big problem. It costs me a few dollars and it costs me about 50 minutes of time to get my permit. I don't think it's an undue burden.
Good morning, Lori House with the Coalition to Stop Gun Violence. In other states, they track some of this information, as the gentleman before me spoke about, but in the Commonwealth of Virginia, we do not track whether persons committing crimes, arrested for crimes, or convicted of crimes do or do not have a concealed handgun permit. We have no idea how law-abiding persons are and that persons committing crimes. We do know that people with concealed handgun permits commit crimes because it comes out sometimes in the press. But as of now, you can't unequivocally say concealed handgun permit holders are the most law-abiding because we don't know that information. We don't know if they are, and we don't know if they aren't. I suspect most are, but you just can't make that conclusion. So without knowing, who's committing crime, whether persons committing crimes and convicted in the Commonwealth of Virginia are or are not concealed handgun permit holders, we just can't make a judgment call. And for many of the other reasons stated here, I think permitless carry has no place in the Commonwealth. I think it puts our law enforcement in danger. They train to approach certain situations in different manners, whether the person is armed or unarmed, whether they have a permit or not. Law enforcement, once a person says, hey, I got a permit, they stand down. They say, oh, okay, you got a permit. I know you have this firearm, and this conversation and this traffic stop is not likely to be dangerous to me. They can actually stand down. So for the danger it can put law enforcement in, and for so many other reasons, the Coalition to Stop Gun Violence opposes the bill. Thank you.
Anyone else here to speak in favor of the bill? In opposition? Back to the committee for discussion. Gentleman Davis.
Thank you. Mr. Chairman, I think the second speaker just proved the point. When he got up and said that getting a concealed carry permit in Virginia is ludicrously easy, and he never had to touch the firearm to get one, that is exactly our point. It didn't provide anything for this gentleman, never touched a firearm, so if he can open carry a firearm, why can't he carry the firearm under his jacket if he never had to touch a firearm anyway when it came to the process of getting a concealed carry? And there already is precedent for this because in Virginia, we've already allowed women that are, I think when there's a restraining order issued against someone else, that we allow them without this class, without a permit, to start carrying concealed. I think we all understand that carrying under a jacket or in your purse has no different responsibility, is not any more difficult, it's the same as carrying open. You have to be just as safe, just as responsible, and the laws are pretty much the same. I know there's other conversation, but I'll leave it at that.
Anyone else? Delegate Howard.
Mr. Chair, there's nothing in this bill that would require the safe, competent carry openly or concealed, and therefore, I think that the idea that somehow it's already too easy to get a concealed carry permit, so making it easier is not going to help us.
Further comment, discussion? Subcommittee operates by motion.
Please report.
Chair, the substitute motion,
Delegate Howard.
I move to lay this bill on the table.
properly seconded to table House Bill 224. Members are ready to vote. Clerk will open the rolls, and members can pass their vote electronic voting machine. Clerk will close the roll. House Bill 224 has been laid on the table now by 62. Thank you, Doug.
Thank you, Mr.
Let's
It's looking very anxious.
Is it? Okay.
Can kill us, Bill? You sure can.
Get on that, make it fast.
I'm gonna defer to, my office chair, Delegate Sullivan.
Thank you, Mr. Chairman, members of the committee. This is House Bill.
Delegate Sullivan, I understand that we're gonna be incorporating your bill into,
The answer to that is yes.
so.
Exactly where I was headed.
Let's do this. Let's ask
459.
Delegate Murphy to come up.
Sure.
And do us.
Let me just make sure the council understands what I think I understand about this. Delegate Murphy's bill, which is 1288, makes certain changes to 18.2-308.1:6, having to do with certain, losing your firearm if you've been convicted of certain criminal offenses. My bill when rolled in, will simply add to the list of criminal offenses that she has in hers. So I'm perfectly comfortable having the bill rolled in, so long as the language itself gets put into the bill. In short, what this bill does is it says you lose your weapon if you've committed a hate crime in Virginia. That's not in Delegate Murphy's bill. But if it rolls in and becomes part of Delegate Murphy's bill, I'm happy.
Mr. Chairman, we do have a substitute, and I would move that we incorporate House Bill 78, House Bill 459, and House Bill 900 into Delegate Murphy's House Bill 1288.
Second. It's been moved and properly seconded to incorporate House Bill 78, 459, 900 into 1288. All those in favor?
And I would move the substitute. You can pass that around.
It's been moved. Is there a second? Moved and seconded that we accept the substitute. All those in favor?
Can we see it first?
Opposed?
Thank you, Mr. Chairman.
We just need to get the substitute so we can have a discussion on all of it. So if there are others here whose bills have been incorporated, that can come join Delegate Murphy, I think that's fine, but otherwise we'll hear from Delegate Murphy, our folks are reviewing. Why don't you tell us what the bill does?
Well, Mr. Chairman, 1288, we're offering this as an amendment in the nature of a substitute, and it addresses a number of critically important gun violence prevention issues. Additionally, the bill brings misdemeanor domestic violence convictions into the Virginia Code and more in line with the federal code as a firearm prohibitor. These are all serious crimes, they're not partisan issues, they are public safety issues. The bill will ensure that Virginia is part of the solution to prevent gun violence and prevent guns from falling into the hands of people who pose significant threat to the safety and welfare of all Virginians. I just want to say very clearly that these are not partisan issues, they're public safety issues. And they will ensure that Virginia has a more positive outlook going forward. I have people here to address the issues if you would like.
Quick question, to council. Do you know the list of the substitute, and if so, you want us to page, or
Sure.
if you just want to run through them really quickly?
Sure, the list of offenses is gonna be on lines 95 to 97. And it is misdemeanor offenses of stalking, sexual battery, assault and battery of a family member, and any offense similar to those three offenses. It does not include Delegate Sullivan's, which was assault and battery when the person intentionally selects another person because of some sort of race, religious conviction, color. So that was not transferred over. That is not in the current substitute.
Do we want that in? That's my understanding.
But that's,
Well, let's see how it goes, and we can make an amendment if that's
Okay.
for the subcommittee.
Any questions at this time of Delegate Murphy? Delegate Davis?
Thank you. Delegate, you mentioned it brings in misdemeanor domestic violence. Can you point me to where that is in here, please?
I don't have it in front of me.
Delegate Davis, I think council
Right,
reference not.
I'm looking on those lines, I don't see it.
It's on 95, Romanet 3, assault and battery of a family or household member.
So, follow-up question, Mr. Chairman?
Delegate Davis.
So, in US v. White, the Fourth Circuit Court of Appeals overruled that assault and battery of a household member is not misdemeanor domestic assault because we use a common law definition of assault and battery, which means I spit on you, it's assault and battery. Whereas at the federal level, when they look at domestic assault and battery, misdemeanor domestic assault and battery, it requires actual, more than de minimis touching, is I think is one of the way the court put it. So how does this bring that in when we've already been overruled by the Fourth Circuit Court of Appeals?
Mr. Chairman, White was overruled by the U.S. Supreme Court in Castleman 4 years after. The Supreme Court held that any misdemeanor conviction would satisfy this. So it just has to be offensive touching, which is what the common law is, which is what Virginia has. So Virginia's laws in Castleman would apply. So so White was overruled.
Follow-up question, Mr. Chairman?
Delegate Davis.
So then if I'm understanding this properly, and I mean, I can refer to the Henrico case recently where a 13-year-old threw a baby carrot at a teacher and got charged with assault and battery. At this point, that would apply. I mean, if I have most Thanksgiving dinners where we have a food fight and it's out of anger, that would apply. That would now be encapsulated in here. I lose my rights for a firearm.
If it was a family member, then that would be a assault. If you were convicted, that could be a assault and battery against a family member.
Thank you, Mr. Chairman. Appreciate it.
Any other questions at this time? Is there anyone here to speak in favor of the bill?
Good morning, my name is Kelly Roscoe, and I'm with the Educational Fund to Stop Gun Violence. We support this bill. You know, for the most part, these are serious and violent crimes. You're always going to find some very ridiculous outliers, but for the most part, these are not non-serious offenses. These are violent misdemeanors, and particularly, one study found that most victims of femicide were stalked in the 12 months preceding either their homicide or attempted homicide, specifically 76% of women who were killed and 85% of women who were attempted to be killed. Violent misdemeanors, research shows that people convicted of violent misdemeanors are at increased risk of committing future violent offenses. Violent misdemeanor firearm prohibitions are associated with a 23% reduction in rates of intimate partner homicide. This is going to go a long way towards keeping the women and citizens of Virginia much safer. It will also allow Virginia law enforcement to enforce, in many cases, what is already prohibited under federal law. As you already heard, DV misdemeanors are federally prohibited for firearm possession. This would bring us in line with the federal law and outlaw those additional violent misdemeanors.
Delegate Hope.
Question for the speaker. Do you have any thoughts about the hate crimes provision that was in Delegate Sullivan's bill and that should be added to this list of crimes?
You have no objection to that being added to this bill.
Anyone else here to speak in favor of the bill?
Yes, good morning, Lori House with the Coalition to Stop Gun Violence. As the speaker before me suggested, there's great evidence to suggest that a history of violence is the single biggest predictor of future violence. And we know that arming people who have committed these types of violent crimes often and too tragically go on to commit homicide of their partner. This is a bill that is necessary on a public safety level, but it also makes sense legally so that law enforcement can, in fact, in the Commonwealth of Virginia, enforce the prohibition on these crimes. If it's only under federal law, you know, our law enforcement are not charged with enforcing federal law, and we know all too well that federal agents are not out there doing this work. It is a bill that's necessary. It's a bill that will keep, for the most part, women in particular, but also there are others who are the victims of domestic violence safe from home and save lives. We strongly support the bill.
Mr. Chairman.
Delegate Hope.
Question for the speaker, Ms. Haas.
Yes, yes, sir.
Do you have any opinion about the language that was in Delegate Sullivan's bill that doesn't appear in this bill regarding adding hate crimes?
Yes, we would definitely support that language being added. Thank you. Again, a history of violence is the single biggest predictor of future violence, and if someone is intent on committing crimes that are targeted at persons for a variety of reasons, we would wholeheartedly support this resolution. Thank you.
Good morning, Delegate Board, members of the subcommittee. I'm Scott Miles with the Attorney General's Office. Your Attorney General supports this bill. He was particularly interested in the language in Delegate Sullivan's bill regarding hate crime assaults. Thank you.
Thank you.
Good morning, my name is Christine Payne. I'm a member of the League of Women Voters and the coordinator for the State Gun Violence Prevention Issue Group for the League. We strongly urge you to support this bill. We support a robust approach to gun violence prevention, which includes at its base keeping firearms out of the hands of people who have a proclivity for violence. So we urge you to support this bill. Thank you.
Anyone else here to speak in favor of the legislation? Anyone here to speak in opposition to the bill?
Philip Van Cleve, BCDL. We would oppose anything beyond the misdemeanor domestic violence. All these other additions are all new things. We're talking misdemeanors here. The key word there being a minor crime. These are not violent crimes. If you think that things like stalking should take away gun rights, then make it a felony. You know, if it's that serious, make it a felony. Why are we playing games calling it a misdemeanor when you're considering it on the level of a felony? That would be the proper way to do it. Then there's proper ways. The whole system's geared towards felonies taking away civil rights, not misdemeanors.
Mr. Van Cleve, can I ask you a question?
Sure.
Would you consider sexual battery a minor crime?
Well, if it's not, then it should be a felony. Why are we making it a misdemeanor? Anybody explain that to me?
What, so that's a, yes, you would consider that a minor
If
crime?
it was, apparently that the General Assembly does because they made it a misdemeanor. Apparently so.
I appreciate
In
your
which case,
answer.
I would say it should
Anyone
not
else here to
be
speak in
taken.
opposition to the bill?
Yes, sir. Patricia Webb, Hanover County, CCL. The problem is that there are catch-all crimes. So in a divorce situation, I've heard instances where one of the spouse yelled at their partner. The partner turned, ran into a wall, and the person that yelled was accused of domestic violence. Now, they didn't intentionally hurt this person, and this would cause them to lose their gun rights over an argument in a divorce situation. The person was not actually violent, and that's why we have a misdemeanor of domestic violence. It is not, in that particular instance, it is not a serious violent offense, but the court has discretion whether to say something is a misdemeanor level or a felony level. And again, I would agree with Mr. Van Cleve that taking away someone's rights for a misdemeanor offense, if it's that kind of violence where you need to take away someone's right, make it a felony.
Let me ask you the same question I asked Mr. Van Cleve. Would you consider sexual battery
I would have to see
lesser
the
crime?
terms of sexual battery. I mean, it would depend on what it is that you're actually talking about. Again, go back to the, I have seen people that are on our sex offenders list that have done nothing more than an 18-year-old that had a young girlfriend, and because the relationship extended to where the 18-year-old hit the age of consent, but the girlfriend was still younger, and then maybe the girlfriend got mad at the boyfriend, or the girlfriend's parents did not want that relationship to continue, and they pressed charges, and then somebody is put in a situation where they now are on a sex offenders list simply because they reached the age of a consent in an existing relationship, and there were family members that didn't want the relationship to continue. So you have to look at things on a case-by-case basis. I would say that if there is a sexual battery that is a violent crime, it should be a felony, not a misdemeanor. And you would have to look at all of these things on a case-by-case basis.
Thank you. Anyone else here to speak in opposition to the bill?
Timothy Ham, Arlington, Virginia. I'd like to remind the committee that in Commonwealth of Virginia, reckless driving by speed can be accomplished merely by doing, say, 10 miles over the limit on Interstate 95 on the way down here in certain sections. That's a Class 1 misdemeanor. On the the same level as drunk driving, many other serious offenses. And number one, I don't see how that's a reckless act, but that's a conversation for another day. And number two, I neglect to see how that should have someone's firearms rights taken away, especially since everybody in this room knows somebody who's been nailed by that statute before, and in my view, painlessly so.
Anyone else here to speak in opposition to the bill? Back to the committee for discussion. Delegate Davis.
Thank you, Mr. Chairman. Mr. Chairman, I just want to make sure we all understand what's going on here. So presently, if you look at federal misdemeanor domestic assault and battery, that requires physical force. Now, physical force doesn't mean I shoved you, you fell over to the ground, hit your head, and then in a hospital, it means I so much as did something out of anger and excuse me, I pushed someone, right? At least that, in an angry manner or some way that is threatening. In Virginia, that is not required in assault and battery. And all of our cases show that, which is why White was overturned. Now, I understand it got re-looked at again, but let's understand, when you want to look at what assault and battery is in Virginia, in Lynch versus Commonwealth, it says that the person that the slightest touching of another, or of his clothes, or cane, or anything else attached to his person, if done in a rude, insolent, or angry manner, constitutes a battery for which law affords redress. If you take it a step further, when you look at Wood versus Commonwealth, it is not necessary that the touching result in injury to the victim's corporal person. It is sufficient if it does injury to the victim's mind or feelings. This is what we're actually going after here. So, Mr. Chairman, I can appreciate what we're trying to accomplish here, but I would argue that any type of violence that already exists when it comes to assault and battery is already encapsulated. What we're trying to say is, you have an angry food fight at Thanksgiving, and your cousin gets upset because you threw literally a baby carrot at them. They can bring up on assault and battery charges. And I know that sounds absurd, but that's exactly what happened to a middle school student when a teacher was actually hit with a baby carrot. So let's just be careful that we don't wrap a circle around a whole bunch of people that make a political point and end up putting them in jail, or and just as bad, taking away their constitutional rights.
Delegate Hope.
Mr. Chairman, I would like to move an amendment to include the language under Delegate Sullivan's bill. I'm looking for the section that it applies to the hate crimes.
Counsel.
Mr. Chair, I believe the language Delegate Hope is looking for is on line 97 of Delegate Sullivan's House Bill 459. After Romanet 1, it says assault and battery when the person intentionally selects the person against whom a simple assault is committed because of his race, religious conviction, color, or national origin in violation of subsection A of 18.257.
I would like to move that amendment.
Mr. Chair, speaking of the motion.
Delegate Corner.
So I've been trying to, I'm not a criminal attorney, I'm a civil attorney, I'm gonna lay that out there right now. So, but words are important, and anytime we're looking to figure out what we mean, definitions are important. And so I've been trying to piece together the different sections of the code that apply to these same acts when they become felonies, which there is the ability to deal with firearms and when they're misdemeanors. And the hate crime section, I believe currently is already covered. If you do a misdemeanor, it moves you over to 18.2-57.
If, for the hate crime section, that's why we use the language of a simple assault, because if it results in something, if the crime takes place with more than just offensive touching, if there is some sort of injury, then it is a felony, in which case the crime would be covered by the current felony prohibition. But if it is mere offensive touching, a simple assault, and that's what it means by mere offensive touching, does not result in any injury, then it still defaults back to the class 1 misdemeanor. So it's not a felony punishment, so there is no disqualifier to take that conduct into account.
Mr. Chair, I would offer a substitute motion to refer this to courts. I mean, I take not lightly at all the issues of sexual abuse and touching, but there's a lot of moving parts in our criminal code. And I know we have a lot of criminal background folks who serve on courts. And, you know, as I look at the definition in 18.2-6710, you know, the touching of someone's intimate parts or material directly covering such intimate parts is under the definition of sexual abuse. And then you go up to the definitions and what that means. I think there's so many layers to what constitutes a misdemeanor. If you do this once, it's a misdemeanor. If you do it twice, it automatically can bump you to a felony. I would feel much more comfortable with those members who are serving on courts having a look at this. I completely agree on the sexual abuse issues, we should be dealing with it, but I just would feel much more comfortable having our courts team be able to fully vet what this means when we're making decisions like this for people.
Second.
Mr. Chairman, let me respond to that because we've had this exercise before, referrals to courts. We've already adopted the substitute, so a motion to refer to courts is improper. The motion would be to report the bill and refer to courts would be a proper motion. But since we've already considered the substitute, it means that we've already put our imprints on it. So just a plain referral to courts is improper. The motion that you would want is to report the bill, means that you support the policy and then refer to courts. Is that your motion?
What is it? Because I don't know, I don't think this is where we should be with misdemeanors. I mean, I think we should be asking them to tackle, do we have enough protections in the felony where the things that should be addressed this way, I think they should be looking at modifying the criminal code sections to deal if this is this serious. I don't feel comfortable taking it up.
So, let me get us in the right posture. Delegate Coiner, your motion, given the state of affairs here, is improper. Do you want to make the motion that Delegate Hope said would be proper, or do you want to withdraw your original motion?
Withdraw my original motion.
Okay. Any further discussion?
I second.
Delegate Hope's
Amendment.
motion has been moved and properly seconded. All those in favor of adopting that amendment will say aye.
Aye.
Any opposed?
No.
The amendment substitutes before us. What's the pleasure of the committee? Delegate Helmer.
Mr. Chair, just speaking to the motion, it seems that there have been some concerns expressed about our misdemeanor laws around assault and battery. And I would offer that the proper place to deal with that is by adjusting our laws in assault and battery rather than protecting the gun rights of those who commit assault and battery.
Mr. Chairman, I would just, if I may, I would just mention to the delegate that they are proper up until this bill. Right now, if you have what the federal government defines as domestic assault and battery, you do lose your rights to own a firearm under federal law. It's by doing this that you lose them by throwing a carrot at your cousin.
Delegate Plum.
I move that we report the bill.
Second. It's been moved and properly seconded to report the substitute as amended, House Bill 1288. Clerk will open the rolls and members will cast their votes. Clerk will close the roll. House Bill 1288, recommends report and not vote 5 to 3. Delegate Logan.
Mr. Chairman, I had one question for you. HB 1287, which asks or requires that employees of firearm dealers,
It's not before us.
I realize that, so it's not included in that.
Correct.
Is it a bill that you'll be hearing today?
No.
Okay, thank you.
Let's hear from our good friend from Arlington, Delegate Lopez. Arlington. I think Delegate Hayes loves this bill.
I used to until I got educated. And then I found a better way.
And so, as they currently stand right now, they're identical bills, correct? House Bill 142 and 264?
That's correct.
And so I would entertain a motion to incorporate House Bill 142.
Mr. Chairman, speaking to the motion.
Delegate Davis.
Mr. Chairman, if I may, I would ask that we do not incorporate the bill. I do have some amendments. If it pleases the body that they want to kill my bill, that's completely fine. But it won't be in the same posture when it's introduced in front of this body.
I think procedurally, either way, we can make the amendments, right? If we incorporate the bill, it's the same bill. But,
Why don't they present both their bills?
okay. Delegate Lopez.
Mr. Chairman, I do have 6 amendments that I'd like to give to the council right now. It's fairly easy to read.
Why don't you tell us about the bill?
Thank you.
Well, let's get the amendments in the proper form.
It's for him.
Oh, okay. I thought we were all taking a look, we knew what we were talking about.
No.
Okay.
Maybe him so he can talk about it.
Mr. Chair, the amendments eliminate on line 33, this deals with the type of training courses available to show competence for a concealed carry permit, would be eliminating number 2, which is completing any National Rifle Association firearm safety or training course. And then eliminating on line 36, those instructors certified by the National Rifle Association. And then again on line 47, eliminating the National Rifle Association certified, and then making those same changes in the non-resident concealed handgun permit section 18.2 3.8.6. So on lines 95, lines 98, and lines 109.
Mr. Chairman, the idea is that naming a private entity as a state source is not normal for the state code, having, and so I thought it was, we can still address the issue at hand, having certified firearms instructors, but it's not necessary to name National Rifle Association in the code.
Second. It's been moved and probably second to adopt those line amendments. Line amendments, correct, Council?
That's correct.
All those in favor?
Aye.
Any opposed? The amendments carry, and so the amended bill is before us. Delegate Lopez.
Thank you, Mr. Chairman. Concealed carry license is required in 35 states, to carry, and about half of those states, concealed carry license recipients are required to demonstrate some level of knowledge of firearm use and safety. Virginia is one of those states. It's required that concealed carry license applications provide proof that the applicant has demonstrated competence with a handgun. There are currently 644,000 active concealed carry license holders in Virginia. However, in Virginia, at no point does a concealed carry applicant have to demonstrate their firearm competency in person. In 2009, the General Assembly passed a law allowing concealed weapon permit applicants to prove firearms competency with a certificate earned through an electronic, video, or online course conducted by a state-certified or NRA-certified firearms instructor. Effectively, this law allowed countless individuals to legally walk around with concealed deadly firearms without a concealed carry permit, without ever actually having had to demonstrate in person actual competence with a firearm. In some cases, when applying for a concealed carry license in Virginia, the online training course is basically a multiple choice quiz that allows participants to retake sections that they failed over and over and over again. Here's the thing, a driving test is required in Virginia to be able to operate a car on our Commonwealth's highways. But a concealed carry handgun permit can be issued based on an online course providers boast can be finished in an hour without ever actually touching or proving actual competence with a firearm. Here's what the bill does. It simply removes the option for concealed handgun permit applicants to demonstrate competence with a handgun by completing an electronic, video, or online course, and mandates that competence with a handgun be demonstrated in person. The bill does not affect any in-person means of satisfying the requirement to demonstrate competence with a handgun under the current law, but a bill does overturn the provisions of the 2009 law that allowed Virginia's residents to prove their firearm competency with a certificate earned online and printed off their home computer. That's the bill, and I hope it's the will of the committee to pass it.
Initial comments or questions? Delegate Davis.
For the delegate, Madam Chair, or Mr. Chair, sorry, the long worded. And Delegate, can you please let me know what the exclusions are to having to get take the gun safety course to get a concealed carry permit, and why you think that people will have handled a handgun before they get a concealed carry permit, given those exclusions? Or let me put it a different way. Is it accurate that if I take a hunter safety course, I'm excluded from having to take the gun safety course for concealed carry?
Honestly, right now, the idea is that this is such a loophole that you can drive a Mack truck through, that I think it's absurd that you can actually do this in the code of Virginia right now. And the fact is that I think you should think that too. In fact, that's why your bill is identical to mine.
Yep, that's why I think this solves this issue too, but I'm good, Mr. Chairman, thank you.
Any other comments or questions at this point from the committee? Anyone here to speak in favor of the bill?
Mr. Chairman, Andrew Goddard, Virginia Centre for Public Safety. Immediately when this law went into place, I went and took the test. I had to sit in front of my computer and hit keys to answer questions. The questions were ludicrously simple. What is a magazine? It's a it a book about guns? Is it the book that came with your gun? Or is it the place where you put the bullets inside? Things like that. That doesn't teach you anything. By the time I was finished, I printed my own certificate. And at that time, it had the name of the instructor printed on the bottom, and it said that he was a National Rifle Association certified instructor. At that particular time, the National Rifle Association prohibited anyone who was a certified instructor to put their name on any certificate, such as mine. So my certificate was actually illegal at that time, in my opinion. So, you know, this is something which needs to be straightened out. People should be able to get concealed handgun permits, okay, but they should definitely be the kind of people that we would want to carry concealed. Thank you.
Josh Horowitz, Fund Stop Gun Violence, we support this bill. I think the longstanding reference to the Commonwealth to have permits for carrying, they should be meaningful. We talk a lot about law-abiding concealed carry holders. Well, if they are, then they should be able to handle a firearm. We'll prove that. They should be sure that they've had enough training to be competent. There's a lot of issues about firearm retention, about when you can use a firearm, when not to use a firearm. These things are best done in person, not in a online test, so we support the bill. Thank you.
Good morning, Lori Haas with the Coalition to Stop Gun Violence. We certainly support the bill. And I believe, I might be right, I don't know, the hunter safety instruction courses are in person. So that goes to support the bill that the delegate is talking about. And we just strongly urge the body to pass this bill. Thank you.
Will Shaw, Louisa County. I've taken the NRA in-person course. It was multi-hour. It was very thorough. And that's what my wife and daughters then took, even though the online option was available. I believe this bill will, however, create a temporary hardship. And I would urge that there be a delayed effective date so that the market can produce more trainers and training, in-person trainers and training classes to match the new law without the online option.
Thank you.
The 6 to 18 month delay.
Thank you. Anyone to speak in opposition to the bill?
Philip Van Cleve, BCDL, again, we're fixing a problem that doesn't exist. Also, if somebody needs to get a permit really fast, this gives them an option. You know, occasionally a woman will find out that her ex-husband decided he wants to kill her or do great harm. This would let her get a permit as quickly as possible. She can take the course, get the gears going. If she wanted to take other courses, then that's fine. She could do that as well, but at least she would have the qualification to get things rolling. And again, there hasn't been a problem with this.
Tricia Webb, Hanover County, and UCDL. I'm also a certified NRA instructor, and I own a gun store, and it's in a rural area. First, I would point out to you that even in a face-to-face course, there is absolutely no requirement in current code, and this bill would not change this, for you to even touch a firearm. So the online course, and I believe one of the amendments to Delegate Davis's bill would have made it so that the online course could not be fast-forwarded. You would actually have to take the course, which I do support that change to the provision. However, the online course facilitates things like if you grew up in a military family and you have already a working knowledge of firearms, there's no reason for you to spend $150 or more on an in-person course when you can spend $15 and take the online course and satisfy that requirement. I would also submit to you that just the premise of concealed handgun permits originally was instituted to keep undesirables from being able to afford a permit to own a firearm or to carry a concealed firearm. These laws have racist roots, and every time we make it harder for people to exercise their constitutional rights, we're supporting that racism, and I'm strongly opposed to that. I would say to you also that permit holders overall are one of the most law-abiding demographics. If you look at statistics, there are less instances of convictions of crimes, violent crimes, among permit holders than even among police officers. And here we are penalizing them again, making it harder and harder for them to exercise their God-given rights.
Thank you.
Thank you.
Good morning, ladies and gentlemen. Mariah Rowland, Louisa County. There are not enough trainers available to do in-person classes when you get out to rural areas. Absolutely right. You can spend quite a bit of time trying to find one. And there's the financial side. It's a lot more expensive. But the basis at this point that I can earn a college degree online and you are not going to invalidate my college degree because I got it online, but I can't get the same information in an online course for my concealed carry permit, it's kind of crazy. Are you guys gonna stop and say that you can't earn a degree online anymore because you have to have in-person knowledge for it to be beneficial for you to learn something? If you don't like the way that the courses are currently offered, change it. Change the requirement for the online course. But I urge you not to get rid of it. There are too many people who can't get to an in-person class, and the cost of the classes vary wildly. She's absolutely right. I've seen in-person classes go for $150 up to $300. I've called about in-person classes and told, oh, we do it every 2 months. You know, the online course gives you the option to take it right now, and it gives you a medium to take it that we accept for practically everything else. So if you understand that your college degree programs, your certifications, that you allow people to get online for other things. The state of Virginia fully supports online courses for a lot of required certificates to go out and do work in different fields. I think we have to extend that over to concealed carry permits as well, as we have. Taking it off and restoring it to what it was isn't gonna do anything that benefits the people that you all are here representing. If you want them to have a better class, mandate that the class is different. But don't take the option away. Putting in laws that we took off aren't going to help us. We're not gonna go back and put Jim Crow laws on, right? We all understand they were wrong. So let's not take this step forward and make it a step back. Thank you.
Good morning, Mr. Chairman. DJ Spiker, National Rifle Association. Delegate Lopez remarked when presenting the bill after the amendments were adopted, this in no way impacts in person. Unfortunately, after the amendments were adopted, this completely changes the way that in-person training is done. The amendments adopted actually gut this code in a number of ways, including sections 1, sections 3, sections 4, section 7. The National Rifle Association, separate from the ILA, which is who I work for, the Institute of Legislative Action, the National Rifle Association is the gold standard of gun safety training. If the goal is to increase safety in education, removing the NRA certification, including, and what these amendments did, including, we're the only program that provides police firearms instruction in the country, which is one of the sections referenced to in the code, that you are able to be certified by a licensed instructor, which is what the NRA provides. By removing that section, we're gutting the opportunity our police and our law enforcement have to supplement their income. We have 125,000 certified instructors around the country. They train more than 1 million law-abiding gun owners a year. But again, by removing sections of this, we're recognized by the DCJS, the DGIF, and other areas as certified and state-certified instructors. So it massively impacts the way this does. Understanding the bill, removing video and online, but as adopted with the amendments, there are a lot of constructive problems with this bill.
Back to the committee, Delegate Halbert.
Mr. Chair, I just have a question for the speaker. Is the NRA currently under investigation, criminal investigation by the state of New York and Washington, D.C.?
There is a ongoing litigation, the NRA backed by the ACLU. There is one individual, I'm not sure that anything has to do with this legislation.
Follow-up question for this
Delegate
speaker.
Halbert, let's keep our questions to the underlying bill.
Oh, all right, yes, sir. I was just asking if it was appropriate, we think it's appropriate for those under investigation or mentioned by the Senate for foreign interference.
Delegate Halbert, I do have a question. You said you represent DCJS, DGIF. You all are licensed, certified firearms instructors, correct?
Yes.
So I wonder how, by just eliminating the name National Rifle Association, you eliminate your ability to still be considered a certified, state certified.
I was because we were given these amendments about 15 minutes before committee, we're still analyzing. There are references not in the subsections, but in the sections of state certification and law enforcement certification as the only program that offers that instruction. That could be, like, there's some constructive areas in
Okay.
it. And again, I haven't had our folks take the time to look at it.
All right,
Delegate, I'm sorry, Delegate, hope that is.
That was my question.
Oh, okay, sorry, thanks, sir.
We're gonna bring it back to the committee for some more discussion, but we've got a couple more bills to get through.
Mr. Chairman,
Delegate.
I do want to ask, if we were to pass favorably on Delegate Lopez's bill, what would that do to your bill?
Well, mine would be a
Make it
separate,
obsolete?
mine would be, it would not make it obsolete. It would impact some of it. I wouldn't say it would impact all of it by any means. So, I would probably have to change, we have to conform mine in part if you pass Delegate
Will it take
Lopez's
them
bill.
up separately, Mr. Chairman? Is that
They could,
preferred?
yes, sir, if that'd be okay, because you could have still part of mine and his.
So I would move to report House Bill 264.
Is there a second? Second. It's been moved and properly seconded to report House Bill 264 as amended. Clerk will open the roll, members will cast their votes. Clerk will close the roll. House Bill 264 recommended reported by a vote of 5 to 3. Delegate Davis.
Thank you. Mr. Chairman, you want me to go down there and stay here?
Sit right where you are.
Perfect. All right, we have a substitute coming around.
Better eye on it.
Why don't you go and start talking about the substitute?
Sure.
And if somebody move the substitute, we'll get in front of us. Second. It's been moved and properly seconded, we accept the substitute. All those in favor? Aye. Any opposed? Substitute, of course, Delegate Davis.
Thank you, Mr. Chairman. So as you probably saw in the original, my bill started out very similar to Delegate Lopez's, but then I realized that and the purpose of my initial bill was I didn't like out-of-state companies making these videos that honestly took advantage of Virginians and others trying to get a Virginia concealed carry permit. Having watched the videos, many of which you've already heard about, some of them don't even talk about carrying concealed. You know, it's some things aren't specific to Virginia law, and people that get a concealed carry permit like to be law-abiding gun owners still, and they want to know the law, and some of the videos don't have that in there. And I don't think they adhere to other requirements that we put on these instructors. So I started out with trying to just get rid of online videos, and then I realized I was having a couple of problems. First is there's already loopholes because the hunter safety course qualifies as the course to get your concealed carry. It is online, it's not just in person, and it doesn't have to talk about handguns at all. Then I realized that reciprocity gets me around having to do a Virginia in person, so that causes a problem. And then I did realize that although I live in Hampton Roads, Mr. Chairman, there are people that live in rural Virginia, and it's not quite as easy as me going down the street for one of a million courses that are taught every week. So I wanted to come up with another way to help solve this problem. So what you'll find, it starts on line 48, and line 48 down. So first it says these online courses cannot allow the option to fast forward or skip ahead. Some of these courses, and I will tell you not all, we have an amazing company in Harrisonburg, Virginia, that trains and does these, and I can tell you after watching 90 minutes of their course and wanting to skip ahead just so I can see what they teach, you can't. So it stops you from being able to skip ahead during the courses. It also requires that the person sign a statement that they attest that they're the one taking the course for the concealed carry, so you don't have someone doing it on your behalf. It also goes down that it actually requires, before someone take the video and pay the money, that whether or not this video talks about best practices, which is discussing what the laws are on discharge of a firearm.
Can I just ask a question of council before you?
Are you looking for one that doesn't conflict with WebPass?
No.
Oh.
I'm looking at lines 151 through 156, and wonder whether or not that particular amendment as part of the substitute is germane or violates any other rule of procedure that we might have.
Mr. Chairman, I would say that germaneness is always viewed in the eyes of the chair. This does add in a tax credit section. It does deal with firearm safety courses, and the bill as introduced dealt with the demonstration of competence for concealed handgun permits. I would just say it's in the eyes of the chair as to whether or not that is closely tied enough to the permitting competency issue.
Delegate Davis.
Sure, thank you, Mr. Chairman. So it requires that the video let the person, before they pay their money, and watch it for an hour, whether they actually discuss this Virginia law regarding brandishing a firearm and being stopped by a law enforcement officer at a traffic stop and things like that. And then it goes down, as I think all of us desire, if you can have an in-person safety course, probably all the better. And because there's so many ways to get around it in Virginia, what I thought the best thing to do is not the stick but the carrot, and offer a $50 tax credit for individuals that take their safety course in person for the purposes of their concealed carry permit. And that's what you see in lines 51 and 56, goes directly with in-person concealed carry gun safety course and the associated tax credit, Mr. Chairman.
Any discussion from the committee members? Delegate Helmer.
Mr. Chair, a question for the delegate. So I recognize this bill still leaves video training as an option for those who are seeking CCWs. As you probably know, in the military, we require in-person training before we even let a private go out with a pistol. Do you really think that we should, for instance, would you recommend to the military that they adopted video training in lieu of hands-on training in person?
Well, no, I appreciate the question. So I would argue that what you do in the military is probably a little bit different than what a private citizen does carrying a firearm for the protection of themselves and their family. Secondly, I would add that if you look at the Virginia Code, there are so many exemptions to having to get this firearm safety course that I thought the best way to make sure Virginians got this additional training was to make it as easy as possible. And using a stick doesn't do it because the loopholes are there. Let's use the carrot and incent them doing this additional training, and let's make sure that those videos clarify that they are taught by a licensed instructor and what is in those videos, so the person's actually getting the information that they think they're getting when they spend an hour of their life and $70.
Delegate Biden.
Mr. Chairman and to the patron, I agree. I think that the online course needs to be more rigorous. I would say there's also precedent elsewhere in Virginia where we allow an online course with no demonstration of capability, and that would be the voter safety course. If you vote in Virginia, you know that you can take this course online. There's sort of exams that you take as you go along, but once you're done, you get a little card that comes in the mail, and you can get on a 75-foot yacht and sail it out if you want to, having never once touched a boat. So I think that it is important that we have, a precedent here, because obviously firearms, we want to make sure that people have some competency and knowledge there, but I would say that this is not an isolated instance.
Delegate Pointer.
Mr. Chair, speaking to the bill, I support Delegate Davis's bill. So I'm a professional working female, and my job requires me to be out all hours of the night. I do zoning cases all over the state of Virginia. I travel a lot. And I had an incident that occurred that made me very uncomfortable, and so I got my concealed carry permit because I realized my size and stature and being out late at night in places I'm not familiar with, I felt like I needed it. I looked up in-person classes. I know how to use a firearm. I come from, my father hunted, taught me, we went out, my husband. But when I started looking at in-person classes, they were very intimidating from a female perspective when you looked at how they were advertised. They were very much geared more towards male places. There were more men where they were. And so I chose the route of doing an online course and getting my concealed carry. I think for women in particular, where it's an area that you really don't want to have to carry, but you feel like you do, it gives you that ability to do it and not be so public about it. I also think for professional working women in particular, it's also, as I looked at other in-person courses, it was very difficult to find anything that met with being a working mom and feeling like you needed this to protect yourself. So I think figuring out a way to beef up the online courses so that we feel confident that the right information is being given. But just speaking from personal experience, I know the value of doing it. I don't disagree we shouldn't beef it up in terms of what's being offered.
All right. Delegate
I
Hope.
have a question for council, because we just passed a bill that says it has to be in person, and now this bill would address the online.
Yes, sir.
So in the first bill, we don't allow that option, but your bill would seem to be in conflict with the in-person requirement. Is my understanding correct, Charles, that they two are in conflict?
That's, Mr. Chair, that would be correct.
Of a small piece that isn't, but you're right, the majority
We
would
should
be.
have presented these together.
Anyone here to speak in favor? Just try to be brief because we know the underlying policy.
Little Grant Cleve, VCDL, we
again, I live in a rural county. I'm up where Hanover, Louisa, Spotsylvania, and Caroline all come together. And people in my neighborhood, if I'm not offering a class, which I can only offer every 2 to 3 months, they have to travel sometimes 50, 75, even 100 miles to find a class. And it costs them hundreds of dollars to do this. Classes are not always a one-day class. Sometimes it's 2 days, especially if it's hands-on with firearms. The other problem we run into is finding ranges that will allow instructors to bring people to the range to shoot. So unless you own property that you can shoot on, there are very limited places where you can actually hold a class and have range time. Again, this bill gives some level of assurance that people are actually going through a course that is related to the concealed handgun permit process, as opposed to having a permit from another state, which we have no control over what's in the context of how you get that permit. Once you've held a handgun permit somewhere, anywhere in the country, it then qualifies, it satisfies that certificate of training. The hunter education course satisfies this certificate of training. And I would also submit to you that many of the in-person classes are nothing more than watching a PowerPoint presentation on a screen. So it's not any different except for where you're sitting. Thank you.
Thank you. I just encourage everyone, both in support and opposition, to be brief, especially on this one, because we just heard basically the same bill before this is a policy decision. So go ahead, I'm sorry.
Mariah Rowland of Louisa County. I don't think they're the same bill, but I understand the need for being brief. I do support this bill. It does improve the issues that, do exist with the online class, but it still needs to be an option. And to address the delegate's point about military service, if you have your DD-214, sir, you are not required to take any class at all. You provide your DD-214, and that is sufficient. So it wouldn't affect you, sir.
Anyone here to speak in opposition to the bill?
Mr. Chairman, Andrew Goddard, Senior Centre for Public Safety. I appreciate the patron's attempt to strengthen the course. I think he's onto something there. However, it would be a better bill if he'd actually struck the loopholes that he was talking about. Striking those loopholes and strengthening the online course to make it really meaningful might be a solution. But this is not that bill, so we have to oppose it.
Josh Horowitz, Friends of Stop Gun Violence, we oppose this bill. Section B says provide an overview. There should be real standards, not, if this is a certification, there should be standards that matter, not just providing what information is in the course. That's what a certification is about. We oppose the bill.
Good morning, Lori House with the Coalition to Stop Gun Violence. We oppose the bill. We think that there should be mandatory hands-on training and in-person course requirements. And with all due respect, the Department of Game and Inland Fisheries reported 12 fatalities with boats in the year 2018. There were well over 1,000 gun deaths. I think we need to be thinking about those. Thank you.
Thank you. Back to the committee for a brief discussion. Delegate Davis.
I was gonna ask a quick question to the speaker.
Sure.
Ma'am, there's 1,000 gun deaths. Can you break them down for me by how many of them were self-inflicted, how many of them were?
About 2/3 are gun suicides.
Okay, and how many of them were criminals that were killed with law enforcement in presence?
Other, I don't know. Other captures, they typically break gun deaths down between firearm homicide, firearm suicide, and other. And other can include accidents like child and toddler deaths, which we've had numerous of in the Commonwealth, but they can also include justifiable homicide, which is often law enforcement.
Thank you.
But they don't break that specific number out.
Sure, thank you.
Thank you.
Any further discussion, subcommittee?
Mr. Chairman,
Delegate Davis.
if I just may say, and I appreciate the committee's time, and I appreciate the gentleman's comment about, the loophole scenario. The goal here is, first off, I thought the most important thing is to tighten up on our online activities, on the online training. And that's why I went with this. If this happens, I'm fine pushing more people towards this, but honestly, right now, if we don't tighten up, there's no reason to push more people towards this online class. So that's where I think this is the first step. And I do think that if in Virginia we want people to understand more about the responsibilities of concealed carrying in the Commonwealth, this is the way we start that discussion, this is the way we move it forward. And I do believe that that incentive, for those that are able to go through online class is there, because ultimately that would be great if people did it. But for the speakers, we understand not everyone has that ability, especially in an emergency situation.
Delegate Hope.
I'm gonna have a motion. Delegate Plum, did you wanna say something before that?
We only got one motion, but it's probably possibly the second one.
Well, I just wanted to explain it. I mean, we just, on the previous bill, we just voted on a policy here that we were doing away with the online courses and doing in person. And I would suggest that if that weren't the position of the subcommittee, then Delegate Davis, I think your bill would be in order, and I think it's certainly an improvement over the process.
Sure.
But given that, I'm gonna move that we lay this bill on the table, because we can't be in conflict with a bill that's already gone through. Majority's already happened.
Mr. Chairman, I say ditto.
Is that a second?
Yes, sir.
It's been moved.
Speaking to the motion?
It's a non-debatable motion, it's been moved and properly seconded to table House Bill 142. Clerk will let the roll, members will cast votes. Clerk will close the roll. House Bill 142 is tabled by a vote of 5-3. Delegate Hope, I think you have a bill in here?
Yes, I do. House Bill 600. And this, Mr. Chairman, is my favorite bill. This,
Shouldn't tell people that.
In all seriousness, this is a very simple bill. It's just 3 lines, and while I'm talking, you'll be able to see exactly what we're doing. It's very simple. This little boy is Cole Clark, who's 4 years old. In May of 2017, he was at a home daycare in, I believe it was Orange County, Culpeper County area, and he was sleeping in a bedroom, and he found a revolver on the nightstand. And he killed himself. This bill just simply says that if you operate a family home daycare and you have weapons in the house, you lock them up. Period. That's all the bill does.
Any questions initially of the patron? Delegate Davis.
Delegate, so just make sure, it's family home daycare, so it would be in a home, and I apologize, I'm just not familiar with some of the terms. And I was looking at, so it would actually be in the home, not necessarily a family daycare situation that is a commercial environment or that sort of thing, or would that be included as well?
Well, there's someone here from the department that can answer that specifically, but the bill would cover licensed, registered, family day system homes, child care subsidy approved homes, and unlicensed and unregulated homes. You may be referring to these bigger ones that are already covered by similar type regs, but I'll let you answer.
Mr. Chairman, Storin, Commissioner of Social Services, yes, this would apply to commercial enterprise called family day homes where a number of children are provided child care in the home of the operator, and it simply creates a requirement for the firearm and the ammunition to be locked in separate places.
Question for the speaker, if I may.
Delegate Davis.
The delegate made a comment that this is already in code for larger variations of this child daycare scenario. Is that the case? Is it, if larger situations already have this requirement of the separation of guns, ammo, separate white cabinets?
So,
No, basically our regulation has that information, but this just basically codifies our regulation that we currently have.
the question is, do center-based child care entities have a similar law or regulation? So this would apply to family day homes.
Delegate Pointer.
Question, so what is the I'm trying to find it, what is the definition in the code for family day home?
So family day home is a home where, what's the maximum number that can be?
So if it's caring for less than 5.
I'm sorry, I can't hear you.
Sorry, Tara Ragland, DSS licensing. It's, if you have 5 or less children in a center, in a home, that are not, you can have folks that are, you can have children that are kin to each other that don't count in those numbers, but it's basically 5 non-related children in a home. That'll constitute a family day home.
So are they licensed?
some that you can license them. They can voluntarily be licensed, but they don't have to be licensed unless they have 5 or more children in the home. So not all of them are licensed.
But this bill would apply whether you were licensed or not licensed?
Yes. This bill applies to any commercial enterprise that's caring for children to separately lock up the ordinance from the weapons.
Mr. Chair, I'm sorry.
Delegate Moore.
So how do you identify non-licensed family home folks? How do you identify them? How do you know where they are?
We know where some of them are, but not where all of them are. So there's a voluntary registration process that some unlicensed family day homes go through. They have to do that in order to receive a subsidy from the child care subsidy program. So some choose to voluntarily license, but some don't go through a voluntary registration. So we would not know where all of them are. It's a commercial
There
enterprise.
could be hundreds or thousands that we don't even know where they are. So the whole point would be that if there is something that happens, then there's the ability to take action, if needed in those situations.
All right, we're gonna take some public testimony. I assume the department is in support of this?
Yes, the governor is strongly
Anyone else
supportive of
here
this
speak in
bill.
favor of the bill?
Yes. Thank you.
Briefly. Quickly.
Grace Reef, I'll be super quick. Child Care Aware of Virginia. Here's the issue. If you self-select to be a home-based child care operator, no one makes you do it, you can self-select, and you also own guns, then this is about safety. Keep it out of the reach of kids. Keep it locked. Cole was 4 years old. The provider put him in the master bedroom to take a nap. There was a loaded weapon. He shot and killed himself. You know, it's tragic. It was an accident. But that family doesn't get another chance for that child. It's over. So we're just saying, very simply, licensed or voluntary registered, so people who self-select to be in this business while caring for people who aren't related to you, keep the guns away from the kids, lock them up, store the ammunition separately. Let's have some common sense.
Thank you.
That's what we're talking about.
Hi, I'm Angela Word. I'm also with Child Care Aware Virginia, but I'm speaking on behalf of Cole's mother, Corinne. She was unable to be here today to speak in support. She'd like to thank Delegate Hope for his work on the bill and supports all child care providers being held accountable as responsible gun owners. It's a child safety issue. People that offer child care in their homes have a responsibility to ensure the safety of their homes. And for those who also happen to be gun owners, this must include keeping firearms inaccessible to the children in their care, because tragedies like this are preventable in all settings, but especially in paid child care, parents should know that their children are safe. So we believe, and Corinne believes, Cole's mom, that this committee has a responsibility to ensure this safety and accountability.
Thank you. Anyone else here to speak in favor? If you're here, support the bill.
Good morning, Lori House, Coalition Stop Gun Violence. We strongly support the bill.
Andrew Goddard, Virginia Senate Public Safety Support Bill.
Kelly Roscoe, the Educational Fund and Stop Gun Violence, we strongly support this bill.
Opposition.
Philip Van Cleve, VCDL, there should be a provision in here that you've got a concealed carry permit, carrying concealed on your person, to be allowed to do that. You should not be totally disarmed. Even the possibility that somebody could show up to harm one of the children in your care, you got nothing. There's no reason not to allow a person to carry concealed as a gun permit.
Tricia Webb, many eons ago, when I was a young mother, I watched one of my friend's children during the day to supplement my income and to be able to stay home with my kids. This would have prevented me from defending them. We lived on a ground floor apartment in a not terribly expensive neighborhood. We were young and struggling. So the ability to protect myself and my kids and the kids in my charge would be taken away by this. There's no provision for concealed carry, and by the way, you don't need a permit to conceal carry in your own home. You can do it without any special permission. I would also submit to you that more children, losing a child in any capacity is tragic. No parent should ever have to bury one of their children. And my heart bleeds for the youngster that was lost and their family. Honestly, it does. But more children die from drowning, from poisoning, from things like that. We don't say you must keep your wash buckets locked up, we must keep your Tide Pods locked up. Yes, there are regulations, there are not laws.
Ma'am,
So,
address the subcommittee, please. Thank you.
yes, sir, excuse me. I would suggest that if there were provisions for types of carry in the home, that this would make much more sense. I see no such provisions in this bill.
Thank you. Sir?
Will Shaw, Louisa County, I'd observed that it's already in law, that it's a crime to leave a loaded, unsecured firearm accessible to minors under the age of 14. That's already a crime. So to some extent, this bill is kind of redundant. But I'm wondering if people would get, there should be a provision for people that are carrying in their own home. I wonder if my wife, who has a concealed carry permit, agrees to babysit for money, that the lady's kid lives down the road, has 5 kids. Does she qualify now as a family day home? And
Thank you.
anyway, there should be a concealed carry
Thank you.
alternative here.
Back to the committee, very briefly, Delegate Helmer.
Mr. Chair, while I was in the Army after a second son was born, my wife chose to run a home daycare. I'm a gun owner. I think it's just common sense that as a gun owner with a home daycare, you store that firearm safely and lock it up and store the ammunition, lock it up safely, and as such, I would move that we report this bill.
Quick discussion, Mr. Chairman.
Delegate Davis.
Mr. Chairman, so actually, I, in concept, don't mind this bill. Actually, I think that there's a responsibility that's embedded in here. I would, one, ask for just an exclusion for a law enforcement officer, when it's on his person, which I don't think that would be an issue. But my concern that I just expressed with the patron, because I really do appreciate this bill, and I do think that it serves a purpose. But the concept of storing your firearms and your ammo in a separate locked container compartment causes me pause. And the reason why is many law-abiding gun owners have a large safe. I have one. And all my firearms and all my ammo is in that one safe. If you were to tell me that I have to store them separately, my firearms are in the safe, my ammo is going in something that is a container and it locks, but a 14-year-old may be able to get into it. So I hesitate to do this because if you make people separate from that one very secure safe that everything goes in and the two things that are separate, one of those things is not going to be so secure, Mr. Chairman.
Would the patron like to respond?
That's not a friendly amendment.
I'm not making an amendment. I understand. I'm not making an amendment.
Any further discussion?
Quick question.
Tell you back.
So who would ensure compliance with this?
That would be the department.
So it's regularly inspected, they come into your home and look to see if you have guns lying
Well,
about?
for the ones that are licensed, that's correct. For the
Yeah.
ones they don't know, it would be much harder. But in this situation, the family did file a lawsuit, and the family was acquitted because there's no law to prevent what they did to occur. And so there is no liability at all. This bill would change that.
And so the current laws that we have as far as, having an unsecured firearm out that's loaded, that was not sufficient?
No, and Grace, you might.
Right,
you were
what happened was,
trial.
it didn't meet a reckless standard. So, the woman who was caring for children, she'd been doing so for, 10 or 15 years. She said she didn't know there was a gun in the bedroom. Her fiance, it's always complicated, he was in the police training academy. He said, oh, I didn't know she was caring for kids. So it was kind of like she said, did he know she was caring for kids? Those kids were there, coming every day. They were getting cash income. They cared for several. Cole was not the only child in this woman's care. So there was a lot of he said, she said. In the end, they weren't convicted. It wasn't reckless. What this will ensure is that if you are in the business of childcare, operating out of your home, and you also own a gun, that you keep it away from kids and the kids are safe. So it's very clear that, we're not using the words reckless. It's not reckless, it's clear. Own a gun, great, keep it out of the reach of kids. We want to prevent this type of tragedy that happened to Clark that happened to Cole from happening again.
Thank you. Further discussion? Subcommittee operates by motion. Been moved and properly seconded to report House Bill 600. Clerk will open the roll, members will cast their vote on electronic voting board. Clerk will close the roll. House Bill 600, will recommend reporting by vote 6 to 2. I believe we have saved the best for last. House Bill 1499 establishes the Virginia Gun Violence Intervention Fund to be administered by the DCJS. The purpose of this fund is to support gun violence intervention and prevention programs. Lots of different ways you can do that, going out into the neighborhood, community outreach, hospital-based violence intervention, group violence intervention program. The bill is not overly complicated. It establishes a fund to provide monies for partners and stakeholders to better educate and engage the community on violence and intervention reduction efforts. And so I'd be happy to entertain any questions. I would defer to the.
Oh, sure. Oh, yes, of course. Anyone here to speak in support of this very fine bill, House Bill 1499?
Yeah, it's Josh Rhodes with the Fund to Stop Gun Violence. Gun violence interruption community programs have been proven to be extremely effective around the country. Supporting these programs, developing community partnerships should be a goal of any gun violence, comprehensive gun violence prevention strategy. Having the state support this or having a fund that can support these laws would be very effective. These are evidence-based programs. They deserve our support, state support, and they're going to save lives in conjunction with an overall gun violence prevention strategy, which I'm happy to see is starting to develop here. So we support the bill.
Thank you. And please briefly, if you support the bill, indicate.
Chairman, support bill. Andrew Goddard,
Thank you.
second, public safety.
Support the bill.
Here with Moms Demand Action, we strongly support the bill, which will help communities such as Newport News to significantly reduce gun violence in their area.
Thank you so much.
Mr. Chairman, in response to Delegate Plum's question, is money in the governor's introduced budget?
Yes.
Yes, it is. Thank you. Support. Yes, sir.
Will Shaw, Louisa County. I support the bill. I would like it to be violence per se, not just gun violence. You're just as dead if you kill with a knife or a hammer. More people killed every year with hammers than rifles.
All right, thank
It should
you.
be violence.
Thank you for those comments. Anyone else who speak in favor of House Bill 1499? Any opposition to House Bill 1499? Yes,
The
sir.
opposition really was stated there in the sense that what's wrong with something against violence? Why do we pick on one thing? If it's a gun, that, you gotta do something about that, but somebody stabbed to death, no big deal. No, it should be against all violence. We should be moving towards a society that's free of people wanting to hurt or kill each other.
Thank you.
Opposed to the bill for the same reasons.
Thank you. Anyone else? I'm sorry, no, go ahead. Anyone else want to speak in opposition to House Bill 1499? All right, it's back to the subcommittee. Any questions for the patron?
I just want to make one final point, Mr. Chair, for those who need to be reminded, just so that nobody would suspect that we're not, this is not a bipartisan idea, despite the fact that we did not get to discuss this bill in July. I believe Delegate Gilbert had a very similar proposal for that special session.
Changes my opinion.
Second.
He doesn't have a line item.
We got a motion to report, properly second. All right, please vote on the electronic voting. Close the roll. The report's 8-0.